All right. Andrew Jenkins.
Anthony, how are you?
I'm good. Good morning, sir. So I'd like to welcome Andrew Jenkins, associate attorney.
Yeah.
With Taylor Law Offices here in Boise, Idaho. I'd really like to thank you for taking the time to come on the 208 podcast and kind of fill us in on some stuff that's not really, run of the mill knowledge for a lot of people. So
yeah, no, absolutely. I'm excited to be here. So
tell me a little bit about, before we jump into law and all that good stuff, like tell me a little bit about yourself, like what interested you about, the legal system and how you became who you are today.
Yeah, no. So I mean, as cliche as it sounds, a lot of people say they go to law school and get into this kind of field to help other people. And, that's really what I wanted to do was, figure out how I could best help my community. Grew up in Cuna, little farm town when I was in it, at least back in the early 2000s. So, it was a lot of trying to figure out how I could help those around me. Law school just seemed like a really good way to do it because, so few people have a lot of experience in the law and the legal system.
Mm-hmm.
And so, when people get into it for the first time, and a lot of times the second or even third time, they're just lost.
Mm-hmm.
And so figuring out how I can help people through that and help guide them through the system was just one way that I thought I could really give back to my community in a really strong and positive way.
Sure. So you've been with Taylor. Have you always been with Taylor, or did you start off as where did you start off in your journey?
No, so I started off as a criminal prosecutor, actually, out in Canyon County.
Oh, wow.
Was there for about 3.5 years, including, internship time when I was still in law school. Jumped over to Ada County, did some civil litigation stuff for the county there. Did a brief stint in-house for a company, and then jumped over to Taylor Law. I've been with Taylor Law Offices for about a year now.
Yeah. Awesome. Yeah. So what would you say is the majority of your caseload? And it seems like you do a lot of like construction and contracts and stuff like that.
Yeah. So I'm the main litigation attorney at Taylor.
Okay.
I do a lot of breach of contract stuff, a lot of construction defect.
Mm-hmm.
That I think that's probably what makes up probably about 80 to 85% of my day is dealing with, contracts, construction defect. Yeah. Just whether it's, pre-litigation stuff beforehand where, the homeowners coming forward and saying, hey, I think you guys, botched some stuff. Or even if it's like full-blown litigation, having to go to court on behalf of a contractor or a company, that's a majority of what I take care of.
Would you say that like between like actual going to litigation and, disputes that happen prior to all that, what would you say is, I don't know, what do you normally see happen on a day-to-day basis and all of that? Like, is it normally we solve it out of court, people just get their heads together, or what's the most common occurrence?
No, I would absolutely say that most of the time we're able to resolve things pre-litigation.
Mm-hmm.
Going to court is a very expensive and time-consuming task.
Yeah.
So a lot of people, once they, really kind of realize that, they're more willing to sit down and try and figure out how to resolve it before we get into court. Because once you're also in court, you lose a lot of that creativity that you can bring to the table in problem solving because you're confined within the rules that you have to follow in court.
Mm-hmm.
If you never make it there, there's virtually no rules that you have to follow, and you can really come up with some good ideas that benefit both sides.
Sure.
For the ultimate benefit of everybody.
Mm-hmm. So would you say that, because a lot of times what I see, as a contractor out here in the field, working with different people from all walks of life, a lot of what I see is like this interpretation of, like, well, I think the law is saying this. So is it a matter of going into like, is it really that black and white, or is a lot of this stuff open to an interpretation?
Yeah, no, there's definitely room for interpretation in a lot of stuff.
Mm-hmm.
That's unfortunately for some cases why we end up in court, is because, you're able to have those two interpretations of something, and, in their own rights, they're probably both somewhat reasonable, or else, you're not going to hold on to that belief too firmly.
Sure.
But there are some pretty black and white aspects of the law, and having that black and white really kind of covers up those gray areas sometimes. And so people kind of get lost in trying to figure out what the black and white is, when really they're more in like a gray situation. They're trying to figure out like, no, it has to be like this one steadfast rule.
Right.
But, it isn't always that clean.
Right. Yeah. It's going to battle, so to speak, is never a clean endeavor. One of the things that you and I have talked about multiple times in the past, and something that we both agreed would be a good topic, is something that even myself, I was not aware of for a long time, and I don't think a lot of other contractors are. And it's called the NORA Act, and what that means. Why don't you tell us a little bit about what NORA really means?
Yeah. So NORA stands for Notice and Opportunity to Repair Act. And basically what it is, once a contractor goes out and does a job, if a homeowner comes back and says, oh, well, I think you constructed the roof poorly, for example, they say, I think you did these 4 things wrong on the roof. They have to bring those defects or their alleged defects to your attention before they can go to court about it. They have to allow you, like the name implies, the opportunity to come and repair it. So you have the ability to come and inspect what they're saying is wrong, and you can, agree with them and say, you know what, you're right. We can come back and we can fix this. Here's kind of what we would propose as a solution. And the homeowner can kind of look at it and say, okay, yeah, that sounds good to me. We'll come up with the day and we'll do that. Obviously, you're also able to say, you know what, I disagree. I don't think we did those things wrong. We're not going to offer any additional services or repairs at this time. And then the homeowner is free to, file a suit against a contractor. The third option is you can say, maybe there is something there, maybe not, but we're not really wanting to deal with it right now. We'll just offer some sort of monetary settlement. So, you don't get taken to court. They get to go and do whatever repairs they believe are necessary, even if, you don't exactly agree. It's just kind of one of those alternative dispute resolution scenarios that you can say, I don't want to get hauled into court for this, but I don't want to take the time to prove that they're not necessary repairs either. So, here's $5,000. Go and make whatever repair you think is needed.
So is this something you normally see happen during the course of the performance of a contract, after, like in warranty situations? Where do you normally see this come up in your day to day?
So I think it comes up way more often when, either the contract is completed or after a contractor is fired. I think those are probably the 2 most common scenarios. You don't typically see it come up during the middle, because, the homeowner's probably still trying to figure out everything that's going on. They're wanting to let you guys do your work and not hover over you most of the time. But I would say for sure that this type of situation comes up after they, come back, they're taking a look at everything. Maybe they have someone else that they think they know a little bit about inspections, have them walk through it, and that person will pick out a few things and say, this doesn't quite seem right.
Right.
And then, they have to provide you a letter, the NORA letter, which lists out all of the defects. And, once they send it to you, you're able to go through those 3 options we talked about a little bit ago, and you have to provide that response within 21 days. So if you don't provide that response within 21 days, they kind of just assume you're not interested in coming and inspecting or doing any sort of repairs. So you kind of lose or waive that ability to reinsert yourself, I guess.
Sure. So is there, because you mentioned the word repair, right? How does the NORA Act really, how does that really apply in a situation, say, like the work is just incomplete? There's not a defect. Is there a difference between a defect and incomplete? What would you say to that?
So I would say there is a difference between a defect and incomplete, because how you arrive at each of those is going to be a little bit different. Incomplete is probably the situation where the homeowner terminated the contract partway through, most likely. I think it's pretty rare that a contractor is just going to leave something undone
In the event of a breach or something.
Yeah. There's got to be some sort of precipitating event, I would imagine, in order for something just to be left halfway done. Versus a defect, that's obviously going to be something, I don't know if a little more serious is the right way to word it necessarily, but something where, it's completed, but the homeowner believes it was done wrong.
Correct,
or something like that. So I do think those are two pretty distinct parts of NORA and of just construction law in general. A lot of times homeowners will conflate them and kind of mix them up and say, well, no, this is a defect because you never got around to it, which, is entirely possible. Might not have gotten around to it because contract was broken, asked to leave, whatever. Any sort of scenario where, the homeowner's just not wanting you around anymore.
Right. Cool. So dive into this with me a little bit. Help me unpack, because I was reading through it a little bit last night, and I wanted to kind of dive into the statute of limitations. You brought that up a little bit earlier about how you have 21 days to respond to their notice. But the language kind of read something that was a little, it left it up to interpretation for me anyways, right? Because I don't really deal with it all the time. But
sure,
it said that it told until 60 days after the period of time which the filing of an action is barred. So the 21 days is, it sounds like the client says, hey, I got this issue, here it is in writing. And then the contractor has 21 days to respond to that. Correct. What is this 60 days after the period of time, et cetera?
So basically, so statute of limitations for contracts, if it's not written down, if it's just an oral agreement between you and me, and I say, Anthony, I want you to remodel my house. We put nothing in writing, which I would never recommend. But let's just say, we never put anything in writing, and we just come up with some agreement. You have 4 years to file an action on an oral contract.
Okay.
And 5 years on a written contract. So what it's saying is, it tolls it until 60 days after. It basically is pausing that statute of limitations and kind of increasing it a little bit for 60 days to take into account the fact that, the 21 days for a contractor to respond has to happen. By statute is required. Within the statute as well is there needs to be a reasonable amount of time for the contractor to be able to come back and inspect to determine whether or not they even want to conduct those repairs, or, if something's incomplete,
sure,
to finish it. So it's trying to take that into account to allow all of these different moving parts within the statute to actually happen. So it pauses that statute of limitations for those 60 days. So those prerequisites can happen, because if the homeowner doesn't follow or substantially comply with the statute, any lawsuit that they file can be dismissed because they haven't complied with all of their requirements.
So it looks like, these statute of limitations really are applying towards, the contractor's ability to respond to the property owner's complaint.
Absolutely.
What is one of the things that I was really having a hard time interpreting in the NORA Act was, what is the statute of limitations for that homeowner or a property owner to do all of this? Is there such a thing, or is it just that 4-year period or 5-year period?
So it depends what kind of claims they're wanting to bring. So if they're wanting to do just breach of contract, it's that 4 or 5 years, depending if there's a written contract or not. if they're wanting to claim, let's say, negligence, saying, your company or your company's employees were negligent in how they completed the contract, that has a 2-year statute of limitations. So they have to bring that within 2 years of the negligent act. So, if the negligent act occurred on January 1st, 2022, obviously we're past January 1 of 24. So that statute of limitations is passed and they can't bring that claim. Obviously, outside of that 60-day extension, if they've begun that process under the NORA.
Right.
So, it does provide a little bit of flexibility given that the homeowner has actually begun trying to comply with it.
Right. So it really kind of sounds like the NORA Act really is geared towards the layman's term is it kind of protects the contractor and, and the court system from like, hey, I don't like this guy. He made me mad, so I'm going to sue him.
Oh, yeah, absolutely.
It kind of puts that stop on the frivolous stuff.
Absolutely. Because, I would be hard pressed to believe a lot of people are going to go through this process just to, pursue a personal beef with a contractor.
Right.
If there's nothing actually wrong with the work that they did, I don't think it would be very common to see these kinds of cases or claims come up outside of a somewhat legitimate concern.
Right. An actual situation.
Yeah.
Besides just spiteful vindictiveness.
Exactly.
Yeah.
Exactly.
And have you seen that, a lot, or is it just like, have you seen people like just go after each other because of a disagreement they had, or like, what is the most common like scenario that you see come out of this?
No, obviously that's played a part in some of the cases that I have seen at points. If there's a disagreement and let's say it gets heated, employees are yelling at homeowners, or vice versa, that obviously plays a part into it somewhat. But again, to go through all of these steps just to go after that personal aspect, I think is pretty rare. There's typically going to be some sort of belief on the homeowner's part that the work was done improperly.
Sure. So I'm going to use this moment to kind of segue into something else, but with the NORA Act, it wasn't until, fairly recent in my company's evolution of our contract, so to speak, it was lien disclosure statements and stuff like that. That's a fairly new law, isn't it?
Relatively, yeah.
Yeah. And a lot of this stuff needs to be in your contracts. You're warning your client like, hey, here's, if we have a dispute, we go through the, these steps of the NORA Act. Does any of this stuff, do you recommend having this in the contract? Is it required legally for it to be in the contract?
Like just like a disclosure of NORA?
Yeah.
NORA itself, no. The liens and all of the information required for liens, yes, absolutely. It's much easier to include that in like your standard form contract instead of having additional pieces of paper that you got to hand over and remember to bring with you to each client. I have seen that in some situations, and some people just prefer it because that's just what they want to do, and that's totally fine as long as that disclosure information is being given. Because if you fail to provide that lien disclosure stuff, it can be pursued, and they can claim that you're violating the Consumer Protection Act. So if you're not including that lien information in your standard contract, making sure that it gets to the homeowner somehow is super important.
And that's, kind of segueing from the NORA into the lien. And I kind of see it as a little bit dovetailed in that, like I typically, when we're talking to attorneys and it's a client contractor situation, usually there's a dispute involved, right?
Oh yeah.
And I see it all the time, moderating the 208 group. It's like, well, I've had this issue over here, and everyone's always just quick to scream, lean it. What is your take from a legal aspect on throwing a lien on somebody's property?
Well, It's kind of difficult because obviously, your ability to lien something is really restricted. You have a very short window to do so.
What is that window, by the way?
So it's 90 days from the last day you did work.
Okay.
So let's say you finished doing work on January 1st of this year. You have 90 days from that day to file a lien in the county where you did that work. So once you do that, you have 5 days to provide a copy of that lien to the homeowner. And if you don't do that, your lien you're not going to be able to foreclose on it. As far as, just jumping to throwing a lien on something if there's some sort of argument, obviously, I think it's always better to try and work something out prior, because the risk you run really is if you throw a lien on there and for whatever reason it's improper, you're exposing yourself to a little bit more liability there for what's called slander of title. Because, once you put a lien on something, title companies are going to know about it. And let's say in the time that the lien is on that property, they try to refinance their home and they're not able to. Well, later on, if that lien is found to be improper and now interest rates have increased from when they were supposed to refi their house, you might be responsible for that increase in interest.
How would they be held responsible for that? Like, what would that example of that look like?
Yeah. So let's say, someone tries to refinance their house on a 3.5% loan. They go to refinance it. Title company sees a lien and says, "Oh, we're not doing that." And then a few months later, they go to refinance again, and it's jumped up to 5%. And let's say in between that time, the lien was found out to be improper. So, lien's gone and they're able to refinance their house at that 5%. Well, because the contractor is the reason that refi was not able to happen at that 3.5% interest, they could be responsible for that 1.5% difference. Yeah. So, it's not exactly something I would suggest jumping at the first chance you get. And if it's a payment problem, obviously trying to work it out with the client, your homeowner, whoever it may be. Maybe they don't have all of it up front. Maybe there's a payment plan that needs to be entered into. You're not necessarily going to know that if you jump straight to liening something. Obviously, liens are a powerful tool. And, if you talk with them and, you're just butting heads constantly and there's no headway made at all, sometimes it's got to happen.
So, going back into proper versus improper liens, I know that I've kind of brought up the topic of the fact that, like, hey, if you're not a registered contractor, then that's one reason why, your lien could not be valid. Can you unpack that a little bit and what that really means for the contracting space in Idaho?
Yeah, absolutely. So the Contractors Board governs, all of contractors. And to be, a quote unquote valid contractor, you have to hold a license or a registration through the Contractors Board, which is through the Division of Occupational and Professional Licensing.
It's a mouthful, yeah.
Oh man, it is. So once you get your license or registration from there, there's statutes, I believe they're in Title 54, that discuss your lien rights as a contractor. And there's a specific section in there that says if you do not hold that license or registration through the Contractors Board, you are waiving your lien rights. And so if you try to file a lien, for example, first of all, it's not valid. And that can get you into that liability of the slander of title I was just talking about. Because if you don't have any lien rights and you file one anyway, clearly it's not supposed to be there. So that 1.5% interest rate increase that homeowner now has to deal with, they can come to you and say, you weren't supposed to file the lien in the first place. Now we're paying, $30,000 extra in interest. That's your responsibility.
Right.
Alternatively, there's another statute. It talks about what are called unilateral non-consensual liens. And one of the subsections within that statute talks about liens that are not typical in the ordinary course of legitimate business. And, the argument can be made that a contractor without a registration or a license filing a lien is not within the ordinary course of legitimate business.
Correct.
Because by statute, they're not allowed to. So a homeowner at that point is able to pursue an unregistered or unlicensed contractor to have that lien removed or extinguished, and the contractor can be responsible for civil penalties up to $5,000.
Really?
Yeah. So it's not something that you want to pursue lightly if you're unsure of whether or not you're supposed to.
Well, and that's something that, I've seen come up a lot with, other associates of mine. I'm a general contractor. I know multiple other general contractors as well as subcontractors. It's been brought to my attention, like, hey, it just seems like, well, there's a dispute. Typically what I see with liens is, a subcontractor either A, breaches a contract or does not meet a quality standard, and then there becomes a dispute over, payment. And even if there is a legitimate breach of contract or whatever it is, that sub can just basically lien the property, which then puts the general contractor in a bind with the client.
Right.
And then the general contractor really can't do anything about it until the homeowner or the property owner says, okay, well, kind of unpack that a little bit for me, if you will.
No, that's an incredibly difficult situation, because like you were saying, as the general, you're kind of responsible for everything, obviously. And so, once you run into a situation where a subcontractor is not getting paid and, they start threatening liens, that puts you in a difficult spot because, along with the lien disclosures that you're required to provide, there's also lien releases that you're able to obtain and provide to the homeowner. And a lot of contracts do and probably should include some sort of language that say, at the end of this, we're agreeing that the property is going to be free of liens, or, the subcontractors are going to sign something waiving their lien rights, or, lien release, some sort of document. That's a hard situation to navigate through with a homeowner. And being the general, you have to kind of act as this intermediary almost
between the sub and the homeowner.
Yeah, exactly. And it puts you in a really bad spot.
Yeah.
And that's kind of why I go back to what I was mentioning earlier about trying to work something out before you jump straight to liening it. Because, the construction community in Idaho's pretty tight. It's, Idaho's not a small state, but there's not a whole lot of contractors that are willing to travel all across the state. So, the community itself is very close. You don't want to start throwing liens on properties as a sub or even a general that can later on cause issues for subs when, that's a potential to burn a bridge, and then later on it might cost you work. But it's just so delicate trying to navigate between how do I resolve this issue with our client, our homeowner, and how do I keep this relationship with the sub and make sure that they get paid. And, it could come down to, as the general, you end up paying the sub, and then you look to the homeowner and say, look, I just had to pay them off to get them off our back and prevent them from liening the property. So now you and I need to work something out.
Right. So, and here's sort of the crux of the situation. And I guess it seems like even if they aren't registered or it's not proper at all, it's like, it sounds like anybody can, like, I could go out and lien your property right now, and then you're basically forced to fight me.
Oh yeah. Yeah, absolutely.
There's no checks or balances with who gets to file liens until after the fact.
Right. There's really not. And that is a pretty significant problem, because the way you do it, you go down to the county recorder's office and you fill out a lien. It's a notarized signature saying that, everything that you're putting in there is true and accurate. But yeah, I mean, the county recorder doesn't really have a way or a mechanism to take a look at that paper. They're not going to call the homeowner and say, hey, has this person done any work at your property in the last 90
They're not going to
days.
call Doppel and check your reg.
Yeah, they're not going to check. I've actually seen a couple documents where there was an unlicensed contractor and he accidentally put down his LLC number instead of his contractor number. And, that's obviously not the same and is going to cause problems. But I mean, the county recorder is not going to know that. They're not going to be able to look at that and say, yeah, I know that that's an incorrect registration or license number. We need to fix it.
Is that something that you see more prevalent in Idaho, or is that just sort of like a nationwide standard that just kind of follows the process of liens?
No, I don't think it's necessarily a nationwide standard. I think there's quite a bit of variance between the states. As far as checks and balances go for it, honestly, I'm not entirely sure. Yeah. I don't know what kind of check could be implemented unless you're filing the lien directly with like Doppel or the contractors board, and liens flow through there and then back out to the counties. I don't know how that would work exactly, because I mean, obviously that's going to add some delay in the filing of the lien, which might require a little bit longer of extensions in NORA or just the statutes allowing contractors to place liens. Maybe it needs to change to 120 days instead of 90 if it needs to take that little detour.
Right.
But yeah, I can't imagine how Idaho itself could implement something with the county at the county level to make sure that they're checking and validating someone's lien rights.
Yeah. Well, I mean, it just would seem to me like if there's a whole section in the legislature dedicated to like, hey, this is what will mitigate your rights to lien. It seems like there should be some sort of like, well, at least a gate kept about like, well, he's not registered with Doppel, so he can't file a lien, right? But I see a lot of times, people just call up Rocket Lawyer and send you an inkjet printed piece of paper that's been notarized, and you're like, well, I guess I got to fight it now, right?
Right, and that's not an inexpensive process either.
Yeah,
the statute we were talking about earlier that can impose the $5,000 penalty against a contractor for filing that unilateral non-consensual lien can also include payment of attorney fees. So, if you talk with the contractor and you tell them, hey, look, man, like, we're going to have to go to court if you're not going to release this lien. We know you're not registered, you're not licensed, you don't have lien rights. And they, tell you to kick rocks and don't release it themselves. You can take that into court, obviously, and tell the judge, once the lien is extinguished and removed, tell them, look, we tried to work with them. We told them this is what we're going to do, how it was going to happen. It happened exactly that way. So, on top of them paying whatever penalty the court imposes, we want them to pay attorney fees as well.
Right.
So, whether that's on a homeowner, that makes it a little bit more palatable, because hopefully they're not going to be out of pocket any money at the end of the day, but there's definitely that front end lift that makes it a little bit more difficult.
So I do know that one of the instances that could invalidate a lien is, obviously, we've discussed not being registered with Doppel for the contract that you're performing. What are some other examples that would, invalidate a lien? Yeah.
So as a general contractor, there's a way to invalidate it when you employ an unlicensed or unregistered sub. That can impact your lien rights. Additionally, like I said, when you do file the lien, if you forget or don't send them their own copy of the lien, if you don't send that to the homeowner
within 5 days,
and that's including weekends. So once you do it, you gotta get it out. That can invalidate it and make it so you can't foreclose on it either. Those are really the main ways. Those three are probably the most common ways to see a lien that has already been filed get invalidated.
And then so let's say, for example, a contractor is working for X amount of time they submit their final bid, right? And then that person, whether it's a general contractor or a homeowner, says, well, I'm not paying you. Is when they're unlicensed or unregistered, whatever it may be for their scope, is it a matter of, well, I'll just go get registered and then I'm good? Or is it during the time you're actually performing the work?
No, that's a great question. So it's actually during the time you're performing the work.
Mm.
So no, if let's say it's an unlicensed sub, they did work for you for 2 weeks. On the 17th day, so 3 days after they're done, they go get registered and then slap a lien on there. That lien is not going to be valid. They have to be registered and licensed during the time they're doing that work. And even more so on top of that, unlicensed or unregistered contractors or subs aren't even allowed to pursue court actions to get paid. So even beyond just the scope of the lien, they can't sue you as the general for payment because, technically by law, they're not supposed to be doing that work anyway.
Correct,
so they're not allowed to go into court and demand that payment.
So it sounds like if you were my contractor and I found out that you weren't registered or licensed in your scope, I could hire you, have you do all the work, and then tell you to just see ya, I'm not paying you. And they can still file the lien, but then I still have to go and fight it. But it's cheaper to fight the lien than it is to pay the contractor.
Yeah, it obviously I would never recommend doing that. But
have you heard of any instances where that's occurred?
Not intentionally.
Yeah.
No, I have seen and heard a couple times where a general and a unlicensed or unregistered sub get into a dispute about payment. And then, that topic obviously comes up, but I've never seen someone intentionally hire an unlicensed or unregistered sub for the purpose of not paying them.
Right.
As a general, like I said, that one can impact your lien rights. But two, there's also another section in Idaho law that says if you do employ an unlicensed or unregistered contractor, you as the general are also exposed to possible criminal penalty. That it's written down as being a misdemeanor, which is 6 months in jail, $1,000 fine. I've personally never seen the Division of Occupational Professional Licensing or the Contractors Board pursue a contractor for anything like that, but I would imagine that was the legislature's intent on preventing exactly that, is putting in there some criminal penalty on the generals to avoid allowing them to hire unlicensed and unregistered people and just blow them off.
Yeah, it's, in 208 contractors, where, one of our main focuses is on, going through the proper channels to operate as a contractor in the state of Idaho. And there's a lot of, like you were saying earlier, gray area where, DOPL doesn't communicate with Secretary of State. Neither one of those communicates with, Industrial Commission. Like all these different entities, it seems like, maybe if they all communicated with each other, there would be like a by proxy, some sort of check and balance. Just because, like we communicate, and if we communicate, we're going to notice that something's wrong. Right.
Right.
But one of the things that, we see a lot in the group is that there's a lot of confusion, a lot of misinformation, a lot of just lack of education on what it really requires, what you are required just as a basis point to be a contractor in the state of Idaho. And a big part of that is, making sure that you're licensed or you're registered, the difference between registration and licensing and all this stuff. But what I see, how do I put it? It seems like there's like a huge disconnect in the state of Idaho. Have you, in this regard, have you noticed that? And what are some of the biggest challenges you've had to overcome as an attorney in that regard?
Yeah, definitely. So it does seem like there's a lot of, I guess you could phrase it as, up and comers trying to break into their own in the, contractor field. And I think a lot of that has to do with the influx of people moving here. Obviously, I've talked with a number of contractors now that are like, yeah, came here from Oregon, I came here from California, and they're raving about how lax the laws are and the regulations are in Idaho. Lo and behold, one of the people I was talking to was unregistered. And so they're talking about how relaxed everything is in Idaho, and they're talking about, all these great projects they've been working on. And I'm like, man, you're not even supposed to be doing that.
Yeah.
You're right. Probably comparatively to California, Oregon, Washington, we do have some pretty relaxed regulation.
Right.
But there is still some.
Yeah.
So, definitely doing your homework on it before you jump out there, break away from your general to go do your own sub work or whatever it may be. You definitely want to make sure that you're in the know as far as how to be properly able to do that work. So I think that's one big problem with the miscommunication is people, moving here, trying to, break away from maybe their own general to get out on their own. And they are not quite aware of all of these little tidbits that, the general has had to deal with for years now, and probably never communicated down to their employees because, not everyone needs to know everything, and there's not enough time in the day to explain it to them anyway. They just aren't aware. And so I think, awareness of it all is a big thing. And I would agree that, if all these different pockets of the government or, these commissions would be able to have some sort of channel of communication, that a lot of that could be fixed. But I mean, I'm sure how quickly the wheels of government turn.
Grinding, screeching, halting. Yes. I mean, for me, one of the things, Andrew, it's just like, it's simple, right? It's like, if you drive a car, we both drive cars. If we let our insurance lapse, the insurance company is required to, there's somebody speaks up and says, hey, this guy, he doesn't have insurance. He's driving illegally.
Yeah.
And they at least say, hey, you need to get insurance because if we pull you over, we're going to pop you. Right. It doesn't seem like a lot of that is really happening in the construction industry. And I get it. It's like, we do live in probably one of the most free market societies in the union, in America today. But it lends itself to this, buyer beware. But there's really not a lot of education for what that buyer needs to be aware of. And there's a lot of education to the contractor as well. Like even in its Title 54, Chapter 52, the Contractor Registration Act.
Yep.
Even in there, it states that like, hey, we are going to give you the laws under which you operate. You will get a copy of them. Right. And I was never given a copy of those. I've been in contract for many years. Right. I mean, we have access to it, of course.
Right.
But there's nobody saying like, hey, Andrew, Anthony, if you want to contract in Idaho, this is how you do it. Right.
Right.
What is your take on that? Is there any way that you could see where, some sort of something can happen in that regard? What would you say would be the next step in that?
I think the next step in it would probably be getting, the contractors board to be a little bit more proactive, kind of like you were saying, in anyone trying to break out by themselves or starting some sort of new contractor business, obviously if they're doing what they're supposed to, which is, I understand is part of the problem that we're trying to discuss right now. But, if they go to the contractors board and they say, hey, I want to be a contractor. I want to do electrical. I want to do framing. How do I do that?
Yeah.
Like, what do I need to know? Yeah, 100%. Then just sliding the statutes over is going to be a really nice step to do that. But, like you're saying, part of the problem is there's a lot of that gray area when it comes to, okay, well, I'm reading through this. I don't exactly understand.
What does this legalese even mean?
Yeah. Like, legalese is a bear of a language to read through, let alone understand. And so I think there's a good opportunity for, maybe at some of the contractor conventions. I know there's a couple of them in Idaho. I can't remember what they're called right now, but maybe having a little bit more open access to contractor conferences, allowing people to come in and, really learn from people like you who've been doing it for a long time, who understand, not just the ins and outs of the work itself, but Idaho as a whole, knowing, okay, got to make sure you stay up on your license, got to make sure, you're doing what you need to maintain your lien rights. Here's how we've been dealing with difficult clients and customers that have been moving in from out of state that don't understand how Idaho contractors work or how busy we are with all of this influx. I think access to that information would be invaluable in making the next step for, more contractors being compliant and making sure that, not only are they compliant, but they're also starting to do good work and avoiding some of these kind of pitfalls that are going to, lead them to court and getting all these NORA letters.
Yeah. I mean, it's just like, it's sort of like, it's almost like, and I hear it, it's alarming how often I hear it, and it's Idaho's a right to work state. Yeah, well, I don't think that means what you think it means, but
Right.
I mean, the thing for me, like when I took my Oregon test to become a contractor in Oregon, right, none of it had anything to do with my ability to perform a trade. I mean, there was a little section in there about, water damage, but for the most part, it was all about laws. And I was really amazed to, learn that, after going through Oregon's laws and then, after going through Idaho's laws, there's some things that Idaho is actually more strict on than Oregon. It's just the difference is it seems like Oregon is just like, yeah, just go figure it out. And when you mess up, we'll fine you or we'll do nothing at all.
Right.
And then it just leaves it up to us to battle it out in the civil arena. It seems like,
Yeah.
Yeah. And I get it. It's, Governor Little has campaigned multiple times on being the governor who has, done away with more regulation than any other governor in the history of Idaho. And there's a lot to that. But I think, again, it's like you said, there has to be something there. And I just feel like, having conversations like this with people who are in it every day, bringing awareness to that. Realistically, what I'd like to see happen is at least a test on, because my test wasn't my ability to memorize what's in that book. My test was, okay, where do I find it in the book?
Right.
You know what I'm saying?
Right.
And chapter or title 54, chapter 52, I mean, you could sit, hour and a half read. In my opinion, you should know those laws, right?
Yeah,
and
absolutely.
It would mitigate a lot of that. And moving on to something that kind of dovetails with that as well. I see it a lot. You've heard of the guy out in Eastern Oregon, took hundreds of thousands of dollars from multiple people. Some of the work he began and it was bad. A lot of the work, he just took the money and never even came back.
Yep.
And that's something that I've seen multiple times in Idaho that really strikes me as unacceptable, where it's like you have all these contractors who are starting these companies, taking these deposits, going bankrupt, and then starting other companies and doing it over and over and over again. And it sounds like it boils down to like this thing that it's intent to defraud, right? And there's this gray area of like, well, was he trying to screw you over or was he just an idiot?
Right.
So
it's a fine line.
Let's dive into that a little bit, because is that just an Idaho thing or
no, that is not just an Idaho thing. To put it plainly, some people just suck. That there's no way around it. And I think the main way to really detect and figure out whether or not someone is really just out to screw you over is, like you're saying, when they're taking money, disappearing for a couple of weeks, and then they're popping up again under a new company name. Those are the situations that I would look at and say, okay, it looks like they're shifting money around to make it so this company A goes bankrupt. They're taking money out of company A to start and form company B to continue doing work.
Mhm.
But then when someone comes back and sues company A for stealing all their money, 150 grand to start doing a house, there's nothing there,
Yeah.
and a lot of people, when they look at that, they're not going to understand, okay, well, he started company B. Can I go after company B then? And in some situations you can, obviously the difficult part is showing that, they moved those assets from company A to company B
Mhm.
for that purpose, for the purpose of making it so the creditors, so to speak,
Right.
can't collect anything on company A.
Mhm.
It's what we call a fraudulent transfer.
Transfer. Yeah.
And you can also often, when that kind of stuff happens, what we call pierce the corporate veil. You can try and go through the company and say, we're also going to include the owner of the company,
Mhm.
because clearly, they're undercapitalizing the company because they're not around for more than a couple months. They don't have the assets or the money to be able to do these projects that they're taking on. The company and the owner are basically one and the same.
Right.
You see that a lot when they start commingling funds. If the owner of the company starts putting money in the same accounts as the business,
Mhm.
you can run into that and say
That's one way to pierce the corporate veil.
it is.
Yeah.
It's one aspect of it. It's called the company is an alter ego, so to speak,
Mhm.
of the owner. And, even though you have an LLC, for example, doesn't mean it's impenetrable.
Right.
So you really want to make sure that you keep those two things separate. But, when you're looking at how to figure out if someone is intending to defraud you, I think that's really one of the big key indicators is,
Transfers of funds.
transfers of funds. Are they moving quickly from company to company? Because I agree, when people are showing up collecting tens of thousands of dollars and then just disappearing, they're probably stupid, yes, but they're also probably doing it on purpose.
Yeah. Well, yeah, I mean, there's a fine line between not understanding, the mathematic structure and dynamic of running a business and be just taking the money and going, see ya,
Right.
you know?
Right. I've seen that a couple times, unfortunately.
So how do we, in your opinion, how do we get more district attorneys across the state to treat that repeated, what I call theft, as a criminal, outside of, because there's a lot of cases where, these guys, they don't start another company, or they just take all this money and they go underground for a while and then they pop up later doing something else. Like,
Right.
how do we, is there a way, in your opinion, to bring this to the attention of multiple district attorneys in Idaho? And like, is there something that can really be done beyond just proving that they've transferred this money and are trying to be shady?
No. Obviously, can something be done? Yeah, always. The question is, are they gonna, take it and run with it?
Right.
But I think, especially when you have someone who's a repeat offender on it,
Mhm.
Obviously bringing all of those instances up and saying, look, he or she have been doing this for 3 years. They've done it twice each year for the past 3 years.
Mhm.
Now they've just stolen $450,000 from these people in our community, and we can't do anything about it.
Right.
It's up to you. The difficult thing is, it's on its face sounds like a civil problem.
Mhm.
And the criminal justice system and the civil justice system are there to serve separate functions.
Yeah.
And if something looks like it's a civil problem, a lot of times criminal attorneys, especially district attorneys or prosecuting attorneys, they're going to look at it and say, this seems like something you should be taken care of through civil court.
Right.
And they'll decline to prosecute it criminally,
Mhm.
and refer you to an attorney to pursue them civilly. But then that's when you run into the problem you were bringing up of, they're just going to throw up a bankruptcy card and say, well, try and come get it now.
Yeah.
And then you're up a creek.
You got to, figure out a way to wiggle through that corporate veil.
Yeah.
The finely thread.
Yeah.
So I want to ask you another question in this regard too, and I realize that there's a level of speculation to it. So just kind of hit it with, the generalization that the best one you can, right? I had a guest on a few weeks ago who was in a situation with a contractor. And this contractor had done just that, taken a lot of different money from a lot of different people and not performed the work, right? And what happened was she was advised through, different entities, government entity, police, sheriff, whatever, to not file a complaint with, I believe it was a district attorney. Well, the district attorney at the time had taken and moved forward on this amount of complaints, but this amount of complaints was only a part of this amount of people, right? And so once these complaints were processed, she was literally told that everyone else that wasn't a part of this is basically just screwed.
Mm-hmm.
And so it seems like the district attorney made an attempt on this civil event, but then once that was complete, they just basically said, yeah, well, you can file it, but what do you want me to do?
Right.
What's your take on that? And how could that have been avoided, do you think?
How could it be avoided that, they only take forward X number and leave everyone else to,
anybody who didn't get involved with the complaint basically just gets left in the dark.
Yeah.
Do you have any input on that? Or
I mean, it's difficult because, obviously
it's a very speculatory.
Well, not only that, but I mean, the prosecutors have a great deal of discretion in the cases that they push forward and the ones that they don't, obviously. I think one of the only ways I could think of right now in making it a little bit more real for the prosecutors possibly is, asking to maybe go set up a meeting with them and say, hey, look, I have this case.
Mm-hmm.
I have a situation where I had $75,000 stolen from me from this contractor. I handed him a check. He went and cashed it, was supposed to show up 3 days later and just ghosted.
Mm-hmm.
Never heard from him or seen him again. And just kind of laying out, any paper evidence that you do have. Because that's a lot of what prosecuting attorneys are going to want to see is, evidence that they'd be able to bring forward. Because a lot of times, in these situations, there's not going to be a lot.
Yeah.
It's going to be a lot of, hey, here's this cashed check that I wrote.
Here's some text messages we have.
Yeah. Here's this little bit of communication, and then they disappeared. I think that's one reason why a lot of prosecutors are hesitant in taking these types of situations forward is because they're hard. They're hard to prove, and especially on the criminal standard, which is beyond a reasonable doubt. Civilly, a lot of times it's by a preponderance of the evidence or clear and convincing evidence.
That makes sense.
Which is lower than beyond a reasonable doubt. And so needing a little bit more hard proof, I guess, would be one way I think that a lot of people could go to them and say, look, here's all of this stuff that you would be able to present to a jury and show them that he ran off with this money. Will it be, will that get them to take every single one? Obviously not.
Yeah.
But might it get them to take a couple more? Possibly.
So a lot of times too, and I see people in these situations, for me, I have the luxury of just chalking it up to cost of doing business sometimes, right?
Sure.
For me, there's a threshold of ROI where it's I'm not going to call Andrew unless there is at least 50 grand that I'm out, right?
Right.
Because I know that the time and money I'm going to spend over the next, was it an average of 2 years that litigation happens?
I think it's a safe bet to say you're going to be at least 12 to 16 or 18 months into it.
Yeah. Well, and there's a point there for me as a business owner where it's just just focus on making more money, right?
Sure.
But for a homeowner, it's a little different. What advice would you give to a homeowner who's kind of in that situation and really not sure, okay, when do I sue somebody? When do I really take this action?
Right. And I think a lot of that obviously is going to be dependent upon the person.
Sure.
But, if they go out and let's say, they go get an estimate and for what they believe to be defective completion of the construction.
Mm-hmm.
And they're looking at something that says, okay, it's between $7,000 to $10,000. I think that's when they have to sit down and kind of think about that ROI. How much money are they going to end up spending on attorneys to go sue someone versus the cost of the repair itself? Obviously, if you're looking at a complete remodel of a house that just got botched and it's $150,000, $200,000 worth of repairs, yeah, clearly that's a completely different situation. But I think when you're talking about that, $20,000, $25,000, maybe even $30,000 of repair cost, that's kind of somewhere where, yeah, maybe consulting with an attorney would be a good idea to kind of talk through that. Because if it's super quick and easy, maybe all it takes is that NORA letter, sending it to the contractor and saying, look, like, you guys, it's pretty easy to see that you guys messed up somewhere. What can we do to make this right before we have to take this too much further?
Right. Yeah.
And that's obviously going to be a little bit more cost effective than, suing someone. But once you're looking upwards of, that $70,000, $80,000 of repair costs, it's definitely more palatable and more understandable that you're going to take those more aggressive measures of looking at suing someone.
Yeah. How much time do you want to spend in a courtroom fighting when you could just focus on, moving forward?
Yeah. Because that's the other part of it, is not only are you having to spend, good money after bad possibly, but, it really kind of grounds you in that horrible experience of, wow, my house looks like crap right now. And it's because of this person. How long do you want to sit in that situation? Well, and on the flip side, on the contractor side, how long do you want to sit there and go, God, these people were just a pain to deal with. I have to deal with them for longer. How long do you want to deal with them?
Yeah. I mean, it just seems like, so that brings up another question, like, as contractors, and I see this a lot in the group too, we don't allow people to just come in and just bash people. Like, if you're going to bash somebody, like, I'm all for bashing people, but, come with pictures, come with contracts, come with, some sort of something that substantiates your claim. And 9 times out of 10, it's like, these people don't even have a contract in place. And is that something you see a lot going on?
Less so now than before, I would say. Obviously there are still people who operate without contracts. And, as you could probably imagine, and I'm sure you probably see, it doesn't always work out super well.
Yeah.
Just because, there can be some question as to what is your scope. I actually saw this somewhat recently where there's a question between the homeowner and the contractor as to, are you a sub or are you the general? And there's no real definitive written contract. So, you have to kind of look at the scope of the services that were completed to figure out, okay, were they hired for this one small specific purpose, or were they supposed to, be there and help out through the entire project? So, I would definitely say, obviously, way better to have a written contract in place. But not only that, the days where I think people can just kind of, get by on that handshake deal are quickly going by the wayside, just because, the kind of society that we're starting to recognize is a lot more litigious, a lot more aggressive in making sure that they themselves are the ones getting protected and taken care of than, oh yeah, no, I know we had this understanding, it's probably a little bit confusing, so let's go back and talk about it more. That kind of stuff is kind of fallen off.
Well, and it even talks about that in the law, like, hey, if you're doing contracting for anything more than $2,000, you do have to be registered with DOPL. You do have to have certain things in that contract, like the lien disclosure statement. And you said it's a misdemeanor with up to $1,000 in fines and even 6 months in jail. What are some of the things, like, to a homeowner versus also a contractor, what are some of the things you would advise that they look for in a contract?
Yeah, absolutely. So obviously, like you said, lien disclosure is number one, because that can expose you to the most liability on either side. As a contractor, then you're looking at possible Consumer Protection Act violations, wanting to make sure that you're not looking at that exposure, because that can actually end up invalidating your contract as a whole.
So let me ask you that on that really quick note, just out of curiosity. I want
Yeah.
to dovetail that into intent to defraud, because in that law, it states that if you don't put that lien disclosure in there, that it can be misconstrued or seen as deceptive practice.
Yep.
Would that be considered intent to defraud?
It definitely could be. I think it would depend on what you're looking at trying to prove for the defrauding. Is it evidence of trying to defraud someone for the purpose of collecting money and just running away? Maybe not. But is it, shady business practice? I think the law kind of speaks for itself, and
Right.
that it thinks it is.
It says that it is.
Yeah, because that's what the Consumer Protection Act is for. It's to protect consumers from shady business practices. And so when you're not placing those lien disclosures in there, letting the homeowner know, hey, just so you know, we're going to do our best to make sure this doesn't happen, but liens can be filed if for some reason payment isn't made, or get into a fight with a sub, and then you're trying to work out a price point for what work they've actually done versus what they bid for. Leaving that stuff out obviously is a big problem.
It's a case-by-case basis, it sounds like.
Right.
So I didn't mean to interrupt you. Back to some of the things that you think, you would advise both contractors and clients alike to look for in a contract.
Yeah. So, lien disclosures, I would probably say, is number one. Having a really tightly well-defined scope, is probably the second one, just because, you never want to come back a couple months after you're done, and your client is sitting there saying, no, you guys were also supposed to do this, this, and this. You're like, no, I don't. Looking at your contract going, it doesn't really say that, but it's not very closed. It's a little bit squishy and kind of open to interpretation on a couple things. As much as you can avoid that would probably be the best, again, on both sides, because you as the contractor, you want to know what you are responsible for.
Yeah.
So does the client. They want to know what you're responsible for, so they know what more needs to be done on the back end. As a contractor, there's the ability to limit your exposure to any potential claims. Exactly. Exactly. So having that stuff put in there is also a really good idea. Obviously the law will kind of curtail that in some situations, but you can always put something in there, and then later on it's up to the court to figure out whether or not it's enforceable or not. So, I see a lot of contracts that say, damages are limited to what you paid us. We're not going to be liable for anything above what our contract price
limited
is.
liability clause.
Exactly. And that's super valuable for contractors, just because if that's not in there, and for whatever reason a client comes back and says, I know I only paid you $100,000 to do this small renovation, but now I'm going to start claiming that there's $300,000 worth of damages caused by you guys. Well, that's a $400,000 swing.
Yeah.
So that's huge. And almost I would say very few businesses can absorb that kind of loss. And so having something in there that kind of speaks to what your liability will be at the end of the day is probably a really good idea. And on the client side, the homeowner side, watching out for that is also good, because maybe that's something that they're willing to negotiate on a little bit. If you see it and they say, hey, I don't necessarily only want to get my money back. Let's talk about it a little bit and see if maybe there's a little bit of room, if there is proof that they screwed something up, and then they have to pay for that repair damage, even if it goes above what the contract price was. So I think those are probably some of the bigger things to keep an eye out for.
What are some of the biggest things that you see kind of going outside of looking at a contract? What are some of the like, what would you say would be the most overarching instance that causes disputes between clients and homeowners that could be avoided easily?
Poor communication.
In what regard?
Oh God, almost any regard that you can even think of. I can't even tell you how many times I've seen, whether I'm representing a homeowner or a contractor, just one person or the other saying they just stopped talking to me. And, maybe that's true. Maybe, you got busy and, their emails just kind of started building and building and building. And you're like, I'll get to it later. I'll get to it later.
Sure.
And you just don't get around to it. I've seen that. I've seen where, there is communication, but it's not exactly answering the questions that the client is asking. They're asking for some sort of schedule, like, hey, when can I expect this to be done? But the answer is, well, we're expecting bad weather and I'm waiting on hearing back from a couple subs. Well, it doesn't really give them an answer to their question.
Right.
You can say, hey, I'm hoping that we're going to be done by this certain point, but I'm waiting on hearing back from a couple subs, and the weather coming in might impact that a little bit, but
sure,
here's kind of our target date. Making sure that there's clear communication between both sides. You could say the same thing for almost any situation, whether it's business, marriage.
Yeah.
How often do you hear just in any kind of fight that communication was at the base of it all?
Right. Yeah. I mean, it definitely sounds like communication is the biggest issue in life in general, or lack thereof.
Yeah.
And realistically, I mean, that's a huge reason why I really appreciate you coming on the podcast. Your expertise, some of your experiences, things that people can learn from. What would you say, if there's one thing you could point your finger at, in your experience working in law in Idaho, like, what is the biggest challenge that we face as a construction industry versus, or even just for clients in the state of Idaho, that you see becoming a reoccurring issue?
I would probably say it's out. I'll venture outside of communication, because that's probably always going to be an issue. I don't think
that could be up to interpretations.
Yeah, well, I don't think there's ever really going to be a way to tell people, hey, here's how you fix that, because communication means so many things to so many different people, and everyone does it differently. But I think having good documentation is one thing that people can do that would fix a lot of problems. Because I've seen some contractors that have really good progress photos of, hey, we're building on this part, we've made it this far, here's what the site looks like right now. And then another couple weeks down the line, they've done a little bit more and they're just getting a lot of good photographs. I've seen others where they've got almost nothing. I've seen homeowners where they say, yeah, all these things are wrong. And I'm like, okay, well, can you show me? And they're like, what do you mean show you? Well, I don't know how bad what you're complaining about actually is.
Well, I watched a YouTube video.
Yeah, exactly. My roof isn't supposed to look like that. Okay, how do you know? Like, what does it actually look like? Are you saying like trusses or like sideways? Like what's going on? So making sure that you have some sort of documentation to show that you're completing your job correctly. And that if a client comes back and says, hey, like this wasn't done correctly, you can scroll through photos, pick a couple out and say, no, look, like here's what it looked like when we were done with it. I'm not sure what else has happened since then, but this is what it looked like when we were done. And on the flip side, homeowners coming back and saying, no, like when this was taken the day after you left, like look at how horrible this looks. I think that's one thing that everyone can do relatively simply nowadays. I mean, we all carry cameras in our pockets anymore. So it's something super simple, super basic. that can really cut down on a lot of argument later on, because it's hard to argue with pictures.
Yeah, or specs and dimensions with signatures.
Exactly.
Yeah. That's something that, I'm really big on within my company too. It's like, when we design something, we're going to put together, a scope of work first. That's usually pretty in depth, right?
Yeah.
And
Yeah.
the more we do it, the more in depth we become, because it's like for me, my contract is a compendium of many years of, that will never happen again.
Right.
Right.
Well, they came back at me for that. So that's going in there.
And that's something I do on a regular basis. I would say at least twice a month. There's something that happens where I go in and I edit that contract, and then I send it out as a memo to my whole team. Like, hey, read this. It's like, every Monday, call your client, ask them how they're doing. Every Friday, tell them, here's what's coming next week, something like that. And it's difficult to do in the sense that, when I say, hey, we're waiting on this material to come in and we're having this bad weather, I expect it to be, by this date, we'll have X, right? I think for me, communication would be like 2 or 3 days before X, like, hey, Mr. Homeowner, listen, this is the situation we're in. I'm just filling you in, or there's no news at all. I find that 9 times out of 10, if somebody's waiting to hear from you and you just call them and say, hey, I don't have any news yet, but as soon as I get updated, you'll be the first person I call. Speaking of which, I need to call somebody after this. So, but Andrew, I really want to say thank you for coming on the podcast today. I really feel like it's conversations like this that will bring more awareness to a lot of stuff, and I see it all the time. Idaho is really poor about like, hey, this is how we're doing things. Idaho just leaves it up to everyone to fend for themselves. Right. And there's a level of freedom in that I really respect, but at the same time, it leaves the door open for a lot of, ignorance. And that's not necessarily stupidity. It's just, we just lack this raw data. And I've tried to get multiple attorneys to come on the podcast and just kind of have this general conversation with me. And you're the first person to do so. And I really would like to thank you for that.
Yeah, absolutely. Absolutely. I'm more than happy to.
Is there something here that we didn't cover today that you'd like to speak to? Something that you would say to contractors or homeowners or just the industry in general?
I think we've done a really good job of covering, what I would consider the basic, most significant issues that I think we're looking at today. Mm-hmm. Especially when you're talking about unregistered and unlicensed contractors and their liens, or including the lien disclosures and contracts. That's something that we're seeing a lot right now is, contractors sending us their contracts saying, hey, can you please make sure that I've got all the appropriate information in here? Mm-hmm. I think the biggest thing I would just want to reiterate is really try and communicate as best as you can with your client, making sure that, if there are any issues throughout the entire project, from planning phase through even a little bit after the project's completion, making sure that if there's an issue, you're not jumping to lien it.
Yeah. Or sue them.
Yeah. Because like I said before, those are powerful tools. They're incredibly helpful when they need to be used. Mm-hmm. A machine gun can solve a lot of problems. It's not exactly the right solution for everything.
Well, sometimes when you solve one problem, it creates 3 others.
Exactly. So, I would just say making sure you're communicating well with your client, wanting to, with the goal in mind of making sure that at the end of the day, everyone's happy to move forward. Mm-hmm. Even if it's, not working with them again, making sure that they're comfortable enough with the resolution that they can go forward. Mm-hmm. I think having that frame of mind is going to be a big step in making sure that, on either side, the homeowner or a contractor, they're not going to need to call me.
Yeah. Yeah. I mean, I often take the philosophical stance that like, hey, legal action, attorneys, is reserved only for those individuals who can't really work their problems out themselves. It's like when that breaks down to a point where somebody else has to come in. That does remind me of another question that you mentioned. Have you noticed there's been a lot of discussion in my group in particular and in our industry about the difference between licensing and registration? Is that something that has been brought to your attention lately as well?
Not really. I've seen a lot of people just use them interchangeably. Whether it's them saying, "Oh no, I'm saying I'm registered," as in I have a LLC registration, but I'm a licensed contractor. Or they'll say, "No, I have a contractor's registration and my LLC is licensed through the state." I haven't seen a lot of people really trying to make that distinction, which is why I've been trying to use both, just because I don't see enough distinction in the law yet that says, if you say you're licensed, then, oh, it means you're not registered. Or if you say you're registered, oh, you're not licensed.
Right.
So, is there a difference? Yeah. Is it a big enough difference to try and argue about right now? Probably not.
What would you say is worth arguing about right now?
Oh man, there's a lot.
Everybody loves to argue.
Yeah.
Everyone says, "I don't like the drama," but we know you do.
That's what I make my living off of, is the drama.
Right. Everybody loves the drama. Man. Well, Andrew, I would say there's probably a few people that I know who would argue the whole license or registration with you, but that's not what we're here to do today. Realistically, I know you've answered quite a few questions that I've wondered about. The NORA Act was something that was new to me, just since recently meeting you as well as the lien. What is it?
Those non-consensual liens.
Well, just the disclosure itself.
Yeah.
Something that I didn't even realize, like if you don't have that in your contract, you could literally, the state of Idaho would come after you for deceptive business practices, right?
Yeah, it's a big consequence for a small oversight.
And you say you've never really seen anybody the state go after anybody for that?
No,
yet.
I really haven't. Again, obviously not to say it can't happen or it won't happen, but
we reserve the right. Yeah,
yeah, exactly. I just haven't seen the AG's office crack down incredibly hard on it, and have kind of left it to the homeowner to pursue that part civilly as well. Because if you violate the Consumer Protection Act, you can ask the court to pretty much invalidate the entire contract, and then the whole thing just kind of goes by the wayside. And all of that language and all of that revision that you did is for nothing.
Andrew, like I said, I really want to appreciate you coming on the podcast. I don't know how long we've been going, but it's been more than an hour. So I know that you're a busy man, and I really would like to thank you for coming on the podcast.
Anthony. Absolutely.
Everybody, thank you for joining the OG 208 podcast. Again, this is Andrew Jenkins of Taylor Law Offices. If you have any questions, feel free to get a hold of him. What's the best way for people to get a hold of you, Andrew?
Man. You can give our office a call. You can come by. We're at 1112 West Main Street. Where that, if you go down Main Street, there's a really awkward looking sign that goes down the corner of a building.
Yeah,
that's ours.
Yeah, I've been in there. It's a nice office.
Yeah, but no, giving our office a call, shooting emails over. My email's andrew@taylorlawoffices.com. Any people that get a hold of me personally, I'll probably just direct you to a link to set up a time for a consultation, and then we'll be able to have a better conversation about it.
Awesome. Well, again, Andrew, thank you so much for bringing all your wisdom and experience on the show and sharing it with the audience. Thank you very much, and have a great day.
Absolutely.
Have a great day, everybody.
Thank you.